This is Bloomberg Law with June Grasso from Bloomberg Radio.
The court is mired in a crisis of ethics. These scandals involving the justices have caused public opinion to question the court's fairness and independence.
After a series of ethical missteps by justices and controversial decisions like overturning the right to abortion and granting broad presidential immunity, only 35% of Americans have confidence in the courts, a record low and a steep drop of 24 points over the last 4 years, according to a Gallup poll. The court has more than 50 cases on its docket this term, including some addressing contentious issues like transgender care for minors, reverse discrimination, ghost guns, and the TikTok ban. Joining me to discuss the oral arguments coming up this year is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. How the court seems to love First Amendment cases, and there are 3 coming up this year. The ban on TikTok, age verification for pornography sites, and tax exemptions for religious organizations. Let's start with the ban on TikTok, which will be the first oral arguments of the year next Friday. The Supreme Court is hearing this on an expedited basis because the ban goes into effect on January 15th. Tell us about TikTok's First Amendment claims.
Well, Congress in early 2024 passed a law requiring TikTok basically to be divested from its Chinese parent ByteDance by January 19th, 2025. And the divestiture requirement has been challenged under the First Amendment and is far from frivolous. And so the court did decide to take an emergency appeal. So it's not exactly on the merits. It would be an emergency appeal about whether or not they're so convinced that the First Amendment issues are substantial enough that they would give an injunction against the statute to get rid of the January 19th deadline. So obviously, TikTok is incredibly popular in the United States, and the fear that led Congress to order the divestiture is the fact that there is not only a Chinese parent, but the Chinese parent here can collect so much information, about 100 million users or so on TikTok, and then change the algorithms by which people see information, and through doing that, influence America in a way that is more pro-Chinese. There's been no evidence that ByteDance and TikTok has done this, but it's certainly, I think, well accepted that they could if they wanted to. So that's what led Congress to order the divestiture. But that raises huge First Amendment questions because it is picking out one particular social media platform and saying that there can no longer be free expression in that venue because of the fear of the Chinese influence. So it really raises a very important but a very novel First Amendment claim, and that's what will be heard January 10th in order to make sure there's enough time for the court to act before January 19th if they are so inclined.
During his campaign, President-elect Donald Trump expressed support for TikTok, saying he got billions of views on the platform.
They brought me a chart, and it was a record, and it was so beautiful to see. And as I looked at it, I said, maybe we got to keep this sucker around a little while, you know.
And Trump put himself in the middle of this by asking the Supreme Court to stay the law without taking a stance on whether it's unconstitutional. His lawyer, John Sauer, the future U.S. Solicitor General, wrote, President Trump alone possesses the consummate deal-making expertise, the electoral mandate, and the political will to negotiate a resolution to save the platform while addressing the national security concerns expressed by the government. It's unprecedented to have a future president intervene in a case before the court before he takes office to try to counteract what the current president has done.
So what's even more amazing about that filing is that it raises a presidential power issue under Article 2 that has never been discussed in the court before, which is what about the Article 2 interests of a president-elect? Because what President Trump has done in a kind of rambling filing is suggest that his prerogatives as a future president should be preserved under Article 2 by deciding to stay the divestiture date of January 19th. We've just never had a case on the powers of a president-elect, and President Trump's filing does raise the issue. It's a can of worms that has not been opened, but it may be opened by the Supreme Court. We'll have to see. Of course, the court doesn't have to reach that issue in deciding whether to stay the case or not, but it's a fascinating sub-issue.
Well, we were all surprised when the court expanded presidential immunity from criminal prosecution. So I suppose anything is possible?
Anything is possible. And, as a political matter, President Trump's submission makes some sense because what the court does by delaying or not delaying the deadline on January 19th will have an impact on his presidency. And so there is absolutely more than a kernel of truth in what President Trump has stated.
And for once, we won't have to wait months and months for the justices to make a decision. The court will have to rule in 1 week's time to beat that January 19th deadline. Now, on January 15th, the justices are going to hear arguments in a case challenging a Texas law that requires porn sites to verify the ages of users. Industry trade groups contend that the law violates the constitutional rights of adults. Tell us about their challenge.
They have two general First Amendment claims, and I think they're quite substantial. The first is more of a doctrinal one. The court below used a kind of rational basis test in order to assess the legitimacy of this statute in terms of protecting minors as opposed to a more demanding scrutiny test. And if their strict scrutiny had been afforded, as it has been afforded to other similar kinds of age restrictions in statutes on First Amendment grounds, that then statute probably would be struck down. So the first challenge is simply, did the court below use the wrong standard of scrutiny, in which case the court might then just remand it back for another go-round with the Fifth Circuit. But the second issue is more predictable, which is if you have age verification on a statute and you require adults to put in, whether it's driver's licenses or other proof of age, you will deter people from going to that site for fear of privacy invasions, for fear of manipulation, etc. So there will be a diminution in free expression by having an age verification on this kind of site. And, the way the statute is crafted, it applies to any site which has at least a third of its material which may be distasteful or have sexual content which is inappropriate for children. Well, how do you determine that if you have artworks on display or if you have some kind of erotic poetry? And so there may be just a deterrence of speech by websites having to self-edit for fear of reaching this one-third threshold, which is very hard to ascertain. So there is a Supreme Court case almost on point of about 20 years ago that looked at the Child Online Privacy Act, and it had an age verification in it, and it was struck down as unconstitutional and never reenacted by Congress. And I would predict that the Texas statute will be held to be unconstitutional as well, particularly if the heightened standard of scrutiny is required by the court.
As you mentioned, this is an appeal from a Fifth Circuit decision, the Fifth Circuit being the most conservative federal appellate court in the country. And every other court that reviewed similar laws has upheld the laws. Texas, of course, has defended the law, with the AG pointing to a 1968 Supreme Court decision that said states could bar the dissemination of pornographic magazines to minors. Is that compelling?
Well, the difference is the websites, right? Once we have a whole kind of different world that can't be cordoned off into magazines delivered or magazines not delivered, we have a new First Amendment dimension that has been added to it.
Next, let's turn to a case involving the First Amendment's religion clauses. The justices will review a Wisconsin Supreme Court decision that said Catholic charities didn't qualify for a religious exemption from the state's unemployment tax.
The question here is whether you can deny a tax exemption to an arm of a religious institution, even though you couldn't deny it to the religious institution itself. So the states that have these exemptions, they say religious organizations are exempt, but how do you tell if it's really a religious organization? And the language in the Wisconsin statute itself basically has to be organizations that are operated primarily for religious purposes, and they use a test to determine not just the motivation underlying the arm of the religious entity, but also their activities. So in this case, the court said, yes, there can be great religious motivations for operating charities, and they lauded the efforts of the Catholic Church to help out people with disabilities, but they said that the actions of the religious group are secular. It's nothing about imbuing people with religious sense or devotion or anything along those lines. And the court therefore made a distinction between a motivation to create a school, for instance, or a hospital, as opposed to trying to encourage religious doctrine. So that is a difficult line drawing issue, and that's the argument here of why it's unconstitutional that it'll enmesh the courts in determining whether these activities are really religious or not. But on the other hand, as the Supreme Court said more than 20 years ago in the Waltz case, sometimes this line drawing for tax exemption is just inevitable. You can't really get around it. You have to have some kind of test in this instance. So that's the test of motivations and activities, separations, and we'll see if the court can stomach that. It's really unclear.
So, but the Roberts Court has expanded religious rights over and over again. Is this another chance for them to expand religious rights?
It is a chance, and it certainly wouldn't be shocking for the court to do that, but it is, I think, only fair to note that if the court decides that Wisconsin cannot make a distinction between Catholic charities and the Catholic Church, that this will give a huge advantage to religious-based organizations that are in healthcare and education who then don't have to pay the same taxes that secular hospitals and secular universities would.
And the effect of a Supreme Court decision upholding this religious exemption would be widespread because almost all the states have laws similar to Wisconsin's. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Professor Harold Krent. We'll discuss whether agency power will take another hit at the court this term and a warning from the Chief Justice. I'm June Grasso, and you're listening to Bloomberg.
Change happens because people care about moving the arc of the universe towards justice. And it can take time. And it can take frustration. I live in frustration. And as you heard, every loss truly traumatizes me in my stomach and in my heart.
Justice Sonia Sotomayor and the other liberal justices have been on the losing side of most of the controversial cases at the Supreme Court in the last few years, with the 6 conservative justices on the winning side as the court decided to overturn the right to abortion, expand gun rights, eliminate affirmative action, broaden presidential immunity, and roll back the power of federal agencies. Last term, the conservative majority overturned a 40-year-old legal precedent in their attack on the administrative state. And there's a case on the docket this term involving the Federal Communications Commission that could open a new avenue for attacks on administrative power. I've been talking to constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law, how the Supreme Court is going to consider a challenge to the Universal Service Fund, which uses a charge imposed on monthly phone bills to help more than 8 million people afford telephone and broadband service. The challengers are trying to revive the so-called non-delegation doctrine that says Congress can't delegate its legislative authority to executive agencies. Tell us a little about the issues here.
This is a Federal Communications Commission rule, but it's done by delegation from Congress. And so the Congress has delegated to the FCC the power to impose this fee. And the first claim against it is that the SEC shouldn't be imposing a fee. That's a tax, and only Congress can impose taxes. This would be a wild argument if the Supreme Court buys it, because agencies apply user fees all the time. And you can look at user fees as a tax, you can look at them as something else, a subsidy. How do you distinguish one from the other? So one way that the court could just cut back, again, dramatically, the power of agencies is to begin to say that anything that looks like a tax can only come from Congress as opposed to the agencies. I don't think the court will go there, but that's at least one possibility. And there's another one that is pretty clear, because the statute itself says that the fee should be, quote, sufficient to preserve and advance universal service. That admittedly is quite vague. And so this is another vehicle potentially for the court to revive the non-delegation doctrine. And that would say that Congress, if it gives power to the FCC, has to be far more nuanced and clear than this sort of broad understanding that they set fees sufficient to preserve and advance universal service. It's just not giving enough direction to the administrative agency. And there's a third side of this particular challenge, which I think is going to be very close on the Supreme Court, which is that the agency has given too much power to a private group. The FCC decided to use a group in this case, which is called the Universal Service Administration Company, which is a private group of mainly people in the telecom industry. They gave them that power to set the fee and provided that if the agency took no action within 14 days, the fee recommended by this private group would become binding. So the court may say that the involvement in this private group makes the delegation even more constitutionally problematic and strike down the structure on that ground. Maybe it's a small point, but I think the court might say, look, the agency at least has to take some positive, concrete action, such as accepting a private recommendation from the group as to the fee before it becomes binding in the name of the United States. For the court to signal to Congress to stop giving too much authority to private parties who are not subject to close oversight by the president or heads of agencies.
You referred to this as a wild argument, and this case is an appeal from the ultra-conservative Fifth Circuit, which often uses novel legal reasoning, and it's split with two other appeals courts in declaring the program invalid. So does it seem like the court took this case to overturn, to reverse the Fifth Circuit?
It's unclear to me. I think that the case has some merit to it. And I think that the court has been interested in non-delegation issues, and particularly non-delegation issues involving power that's shared with private parties. So I'm not surprised that the court took this case, and there is a split in the circuits, and I don't think we can be confident that the court's going to rebuff the Fifth Circuit in this particular case. I think they will in other cases, but not necessarily in this one.
There's an interesting case involving a claim of reverse discrimination in employment and what plaintiffs have to show to support their claims under Title VII.
Yeah, so in order to advance a Title VII case or discrimination case, you have to show kind of a prima facie case that you were treated differently than another covered group, and that because you were treated differently, it resulted in some kind of adverse employment action. So to even get to the pleading stage, one has to allege these particular type of harms. Now, what happens if you're a member of majority religion or majority race, or if you're straight in terms of your sexuality, and if you then make a claim that even though you're straight, you were treated unfairly based on your straightness, and therefore you are claiming some kind of discrimination that's protected under the Act. And indeed, in the Ohio case, there was an individual who is straight, and she didn't get a promotion, and instead the promotion went to someone who was gay, and then was later demoted, and someone took her old position who was gay as well. And even though someone who was straight made these employment decisions, she claimed that the decision was in violation of her statutory rights to be treated the same as anybody else based upon her sexuality. And a number of courts have held, but others have disagreed, that there is an additional hurdle that somebody who is of majority religion, race, or who are straight, as in this case, has to surmount before they can get into court, and they have to show background circumstances to give more sort of color or more oomph to their argument that they were treated unfairly based upon covered characteristics. And in some ways, that requirement makes some sense, because for a court to have to go into any kind of analysis, and that just wastes time, because it's so unlikely that if you're a majority, you'll be subject to discrimination. And so those courts said then, as a way to conserve resources, we just want to make sure that somebody who pleads the case will show a little bit more of those background circumstances, which suggests, despite the fact that they're majority, they were subject to discrimination.
And this decision could have ramifications for DEI initiatives. Hal, before I let you go, let's talk a little about the Chief Justice's year-end report, which he issued on Tuesday. He defended the independence of the judiciary, but said it was being threatened by violence against judges, intimidation of judges, and the prospect of federal officials defying court orders. Roberts' annual reports typically ignore the current concerns surrounding the justices. For example, last year he looked at the judiciary's role in integrating public schools after Brown v. Board of Education, with no mention at all of the court having overturned the constitutional right to abortion just a few months earlier. So what's your take on this year's report?
You can be empathetic to his wish and his hope and his fervent desire that the Supreme Court retain its independence and respect in our society. And I guess on one hand, you could be skeptical, given that a lot of the loss of support and respect for the court has come because of this court's decisions, most notably Chief Justice Roberts' decision in the presidential immunity case and the abortion case as well. But, I think he is right that we are in this politicized world even more open to attacks upon judges than we were before. And there's been picketing in front of justices' houses, as we know, and that's something to be probably a little bit frightened of. But there's also been other kinds of defiance. Vice President Vance has suggested that certain times it's totally appropriate for the administration to ignore what the Supreme Court would hold. So there are challenges coming from various different sectors. People that just disagree with the court, as well as what people think that they don't have to listen to what the court says. So there is reason for Chief Justice Roberts to decry those kinds of challenges to the court's authority. But I think at the same time, part of the problem is the court's own doing.
And according to the U.S. Marshals Service, the volume of threats directed at judges has more than tripled over the past decade. So certainly that's a concern. But when he talked about intimidation and he mentioned protesters, quote, intent on harassing judges and public officials, he said, have tried to intimidate judges by suggesting political bias is behind their decisions without a credible basis. Both of those seem like First Amendment protected activities.
They can be, right? It's a fine line to draw between when they are harassment as opposed to when it's just criticism of the court. And the way to, I think, see this clash most plainly is to talk about the immunity decision. And some people can criticize it as being badly crafted. Others can say it's just illegitimate. And those are two ways of criticizing the opinion. And it's hard to say what is really the difference between saying it's poorly reasoned as opposed to it's politically lawless. Those are just different perspectives if people don't accept the opinion. And so I think he's conflating one with the other to some extent, but it is notoriously very difficult to try to figure out what is legitimate dissent, protest, as opposed to one saying that the Supreme Court is lawless and we should have a quick overhaul of the entire judicial system.
Roberts specifically criticized threats to ignore federal court rulings by elected officials, which he said had come from across the political spectrum. But as you mentioned, Vice President-elect J.D. Vance had said, and when the courts stop you, stand behind the country like Andrew Jackson did and say, the Chief Justice has made his ruling, now let him enforce it. I just want to mention that not only is Vance a lawyer, but his wife clerked for the Chief Justice.
Which is an odd turn for sure. And the Andrew Jackson issue arose, at least allegedly, out of protest from a Supreme Court decision saying that the removal of indigenous peoples from a particular reservation was illegal and, ordered the administration to comply with it. And by all historical measures, Andrew Jackson refused and continued to disband the indigenous communities. And, with the vice president articulating that kind of issue, it's putting into play this notion that the court is just another political arm of the country and that it should be subservient to the president and vice president who were elected and given a mandate by the voters, unlike the Supreme Court itself. And that is a dangerous notion, and maybe some progressives have flirted with it as well in frustration with what the court has done recently. But now the court is being challenged by members of its party who appointed most of them, the Republicans. So they have reason to be nervous because they're now potentially going to be challenged by both sides of the political spectrum.
It's going to be an interesting year, that's for sure. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up, dueling lawsuits over Blake Lively's claims of sexual harassment on a film set. I'm June Grasso, and this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
That special connection you feel, that first kiss. But 15 seconds, that's all it takes to completely change everything.
I'm so sorry.
The biggest drama in Hollywood these days is not a film, but the legal drama surrounding the hit movie It Ends With Us, starring Blake Lively and director Justin Baldoni. There are dueling lawsuits and probably more to come. Lively sued Baldoni, Wayfarer Studios, and his PR team on Tuesday, alleging sexual harassment and a coordinated campaign to undermine her reputation for coming forward about sexual misconduct on the set of the movie. This came after Baldoni and his publicists filed a $250 million defamation suit against the New York Times, claiming the newspaper defamed them in an article about Lively's allegations, which they claim was rife with inaccuracies, misrepresentations, and omissions. Joining me is labor and employment lawyer Nisha Verma, a partner at Dorsey Whitney. Nisha, tell us about Lively's lawsuit.
Blake Lively ultimately filed a lawsuit in federal court in New York, alleging the same allegations that she had previously indicated about 10 days earlier in a complaint that was filed with the state agency in California that handles discrimination and harassment complaints. The complaint accuses Baldoni and the CEO of Wayfarer of engaging in inappropriate sexual conduct on set, but that's not all. The very interesting thing about her action is that it shows text messages between Baldoni and his publicist, which indicate that he hired a PR team to combat any potential negative PR if Lively goes public with what the internal messages call her grievances. Those text messages between the publicists are explosive. So in one exchange, Baldoni's publicist, Jennifer Abel, relays to another publicist, Melissa Nathan, that Baldoni's not satisfied with this PR plan that's been put forward. And we can see from reviewing it, a PR plan, that it is designed to discredit Lively. And there's a concern that's quoted by Baldoni that he doesn't feel like he's getting the protection he needs. And another publicist then responds saying, "We can bury anyone, and we can't write that we will destroy her," noting what would happen if the communication's gone to the wrong hands. There are also texts that show that these two original publicists hired another agency to engage in some sort of social media activity on a wide scale that would shift the narrative from Baldoni to Lively. But the important thing to understand is that the core of the case is the same employment claims that we see filed by any other individual that goes through this state agency, which is sexual harassment and retaliation. And so the core of the sexual harassment complaints are that Baldoni was engaging in unnecessary sexual conduct, unnecessary sexual comments on text, and that Lively and her team brought forward their concerns during the writer's strike in late 2023, and the studio actually agreed to meet Lively's conditions prior to resuming filming. Lively's complaint in and of itself says that filming proceeded smoothly from that point, but then there's this very specific action of Baldoni closer to the time of marketing the film, after filming, hiring these PR agents to discredit Lively.
Taking the first part of her allegations about harassment on the set, what kinds of things specifically does she complain about?
So there's an example of Baldoni and another producer speaking about a pornography addiction. So that's something that I'm gathering is alleged to have occurred when the filming was not occurring. There's also allegations of a sex scene being filmed and Baldoni going off script and engaging in things that were not previously agreed to.
Baldoni has disputed Lively's claims, and in his suit against the New York Times, he claims that the Times deliberately omitted portions of text exchanges and other information that contradicted Lively's version of events. He's also claimed that Lively wanted to wait to meet with an intimacy coordinator when production started and that she advocated for her character's clothes to be sexier. I mean, if this goes to trial, is this all going to be a jury question about whether this constitutes sexual harassment?
Yeah, I think the question of whether there was sexual harassment on the set of this movie is highly factual. I don't think there's a ton of interesting legal questions. As to that first part of the lawsuit, I do believe that comparing Lively's complaint and Baldoni's complaint does not simply answer the question with respect to Lively's allegations. For example, the text that Baldoni shared in his complaint, as you mentioned, against the New York Times, I believe it shows that Lively did not need to meet with the intimacy coordinator in advance of starting filming altogether. Lively's allegations about the intimacy coordinator is that during the actor strike, before they resumed filming, so this is several months after probably that first text, Lively required an intimacy coordinator on set at all times. So while Baldoni's complaint appears to go to the content of an intimacy coordinator, it doesn't in and of itself answer the question as to whether Lively's allegation is accurate.
Let's talk about the retaliation claim. He hired a crisis PR team. Lots of high-profile people and even companies hire crisis PR teams. What does she allege that makes that actionable?
Interestingly, like any other employee that brings a retaliation claim, Lively is at her core asserting that she was subject to sexual harassment. She brought a valid complaint against that, and then she was subject to an adverse employment action as it relates to her complaint. Those are the elements of at least the California and federal claims that she's bringing. Now, that is what I think raises the most interesting legal issue here, is that her argument is not that she was fired from the movie. Her argument isn't that she was demoted. Her argument is that her employer hired outside professionals to discredit her in connection with the marketing of the movie, in anticipation that Lively would ultimately come forward with her complaints, which Lively maintains are protected. And so I think there's a couple preliminary questions there. Was Lively an employee of some of these people this entire time? Did her employment start and end during the filming of the movie, or did she continue to be an employee during the marketing? Can there be an adverse employment action to someone who maybe is no longer your employee? That's an interesting question. And then two, does this conduct of hiring publicists to discredit Lively in anticipation of her coming forward with her grievances constitute an adverse employment action where Lively's complaint in and of itself speaks to that damage of the adverse employment action being done to other brands that are unrelated to her employment on this movie and employment with Wayfarer, her beverages brand, her hair care brand, obviously her ability to appear in additional TV shows and on Saturday Night Live. There's an interesting and serious question as to whether taking action that might interfere with her ability to essentially work other jobs is an adverse employment action in this job.
If his conduct on set didn't rise to the level of sexual harassment, what happens with the retaliation suit?
The question for the retaliation suit isn't necessarily was she actually subject to retaliation under the elements of the law. It's did she have a good faith belief to believe she was subject to sexual harassment, and did she raise a complaint about that? And she did. The documentation during the actor strike indicates that she did raise that complaint. And the root of the retaliation action is based on her complaint, whether it was 100% true or not, did her employer act in a way adversely to her employment? That brings us to the separate tricky question, which is hiring publicists in this manner tantamount to an adverse employment action when perhaps the person's employment is over?
It seems like there's a lot having to do with the press tour and that Baldoni stepped away from the plan that the team originally agreed upon and was focusing on female trauma rather than female triumph, and that Lively and just about everyone else went in one direction and he went in another. Also that they were vague about their comments on Baldoni's performances and directing. So it seems like the camp's divided there. So wouldn't he have a right at that point to try to defend himself? And you might call it retaliation, but he might call it defending himself.
And he uses those words in the longer text that are included in Baldoni's complaint against the New York Times. Following the portions of the text that I read to you with the very salacious and explosive comments of "we can bury anyone" and "we can't write that we will destroy her," there is further context where the publicist is indicating that this is all an effort to defend you because you deserve defense. I think that is going to be a highly factual question in the case. I don't know that it's going to be determinative because Baldoni's materials that he includes in the New York Times complaint don't dispute the core allegation by Lively that these individuals were hired to discredit Lively, and one of those reasons is because there was an anticipation that Lively was going to bring forward her grievances as stated in their materials, and it cannot be separated that one of those grievances is Lively's allegations of sexual harassment, which should constitute protected activity under the laws she's suing under. The fact that there was an underlying sexual harassment complaint here makes some of the later motivations, I think, potentially less relevant when we come to the legal analysis of what Lively is alleging.
He filed a defamation action against the New York Times for $250 million. He hasn't yet filed a lawsuit against Lively. What do you think the strategy is here on his side?
I believe he filed a lawsuit against the New York Times because he knows his ability to file a lawsuit against Lively during those 10 days was incredibly limited. The first legal action to be filed in this, we'll call it a controversy, was Lively's agency complaint with the California Civil Rights Division. Filing a defamation lawsuit based on somebody's submission to that agency or filing some sort of countersuit would not go very far at all. It would be subject potentially to an anti-SLAPP motion. And again, filing something with a state agency like that is considered privileged if there was a defamation action. So in order for Baldoni to get essentially his side of the story out, I believe the lawsuit against the New York Times was his available avenue to do so.
So she filed that complaint in California. And hours after he sued the New York Times, she sued him in New York. What's her strategy?
Well, I'll speak to the states first. So I understand from her original contract, which is alleged in her New York complaint, I understand that there was a California choice of law provision. Therefore, that does explain the submission of the civil rights complaint to the California state agency and invoking California employment laws. Simultaneously, Lively's complaint, which is filed in New York, does allege that much of the conduct between the parties occurred in New York. Lively and her husband, Ryan Reynolds, have a residence in New York, and I believe a lot of the business transactions occurred in New York.
How do you think this goes down? What happens next?
All of these people who are sued have to respond to their complaints, right? That's a lot of people. Another fascinating aspect of this case is that we've talked about essentially 3 legal complaints. There were actually 4 legal complaints in 10 days because the original PR firm that Baldoni was engaged with, the owner of that firm has sued her former employee, who is one of the publicists we've been speaking about, for breach of contract, and she's also sued Baldoni. So like I said, all of these individuals that have been served with lawsuits have to respond. Taking them one at a time, I think the lawsuit against the New York Times is going to be one that's more likely to be handled on a procedural basis. The New York Times can bring an anti-SLAPP action, and it has successfully done so with respect to other similar lawsuits, including one by Donald Trump. They also have defenses with respect to the defamation action because there is a requirement that Baldoni show malice. And there's a serious question as to whether his complaint even attempts to do that. For example, there's numerous times where Baldoni presents a longer version of a text message that Lively had produced in her complaint, but the longer version of the text message doesn't necessarily contradict what it is Lively is at her core alleging in her complaint. It just provides more context as to what these people were talking about. Really briefly, there's an example of Lively producing a text message between the publicists that does not include an emoji, which we can see is because these were forensically pulled, and Baldoni producing a separate version that includes an upside-down emoji and indicating that that upside-down emoji indicates the text message was sarcastic and that the New York Times should have noted that. That is going to be challenging to parlay into actual malice, which is necessary to bring a defamation suit on a public matter like this.
Do you think a settlement is likely here?
No, I don't think so. I believe these complaints were in part filed because each of these parties needed to tell their story in light of the other content about them out there. And now that that's happened, I see an expectation that that process continue. I don't know anybody's motivations, but the overall story does not indicate that any of these actors primarily filed their lawsuits for money. And settlement typically only gets you money. It can't change the public perception.
So then a lot more to come in this particular Hollywood drama. Thanks so much, Nisha. That's Nisha Verma of Dorsey Whitney. In other legal news today, President-elect Donald Trump has lost his bid to get his conviction in the New York hush money case thrown out before his inauguration later this month. On Friday, Judge Juan Merchan refused to toss the jury verdict. Joining me is Bloomberg legal reporter Erik Larson. Erik, tell us why the judge made this decision.
Judge Merchan said that Trump was essentially requesting to expand what we already know of as presidential immunity from criminal prosecution, to extend that to a president-elect. And the judge indicated this, was unprecedented. There has never been a case like this before, and that the established presidential immunity for a sitting president has never been extended to a president-elect, and the judge said there was no reason to do that now.
Did you find any of Trump's arguments to have a jury verdict thrown out persuasive?
Trump's lawyers essentially just pointed to the established precedent for a sitting president being protected from criminal prosecution, saying that previous Supreme Court precedent and the Justice Department's own internal policies on prosecuting a sitting president, that they relate to the imposition of a criminal sentence essentially being a bad look for a president because of the stigma associated with it, and also the mental and physical demands associated with the defendant helping prepare for their defense, that all of that would interfere with the president's duties. And I think that in Trump's view, he's saying that while he's not a sitting president, that he has so much work to do and that he has so much responsibilities as a president-elect that essentially the same protections should be extended to him for the same reason. But Judge Merchan just wasn't having that and said that he was forbidden. The judge said he was forbidden from recognizing any presidential-elect immunity, saying that that would essentially be a retroactive dismissal of criminal charges against a defendant who happened to be elected president after they were convicted, and that he just wasn't going to do that.
And the judge set a sentencing date for next Friday.
And he also took the unusual step of indicating in this ruling that he has no intention of sentencing Trump to any period of time behind bars. And as we know, for the crimes that Trump was convicted of, he faces as long as 4 years behind bars. Many legal experts, even before Trump won the election, predicted that all things being equal, he probably would get far less time behind bars than that, or probably more likely no time, and it would just be probation. So it's not a huge surprise that the judge is saying he's not going to sentence him to time behind bars. But he did take the unusual step of signaling that, just so everyone is aware, that he's not on January 10th going to be sentencing Trump to prison. But of course, that leaves up in the air what the sentence will be. If it could be a period of probation or something like that, all of that would also be unprecedented for Trump to have a sentence of any kind handed down, 10 days before his inauguration. So we can expect probably, I would think, a very quick attempt at appealing. But it's unclear exactly how that's going to work. He can't appeal the verdict itself properly until he is sentenced. He may be able to appeal, this ruling. So we'll have to wait and see on that. And by the way, the judge gave Trump until January 5th to decide whether or not he wanted to appear in court for the sentencing or appear virtually.
I know you'll be there, Erik. Thanks so much. That's Bloomberg legal reporter Erik Larson. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.